Data Privacy Party installment. Hunter Sunbeck here to give you a quick update around something that happened not too recently ago, but there's a lot more states passing data privacy law, statewide privacy law, that is, and one of those is Utah. Senate Bill 227, in case those of you that are keeping up with the actual names of the bill rather than the short names that they attach to them. And I want to kind of talk about some of the stuff that really applies to consumers. The whole point of the Data Privacy Party is to help individuals like you and me just really understand what it is that's going on with these privacy laws. What kind of rights do we have as data subjects? Basically, what we can do, what rights that we have as individuals whose data is being used to make money for other companies if they're selling it, whether it be for their own, just an asset that they use to sell, much like, you and I would, a home or a car or something else that we own, or something to, do some targeted advertising with. We kind of see that a lot with, especially in the past, where, companies would use specific data, kind of big data. We heard that term quite a bit 10-ish years ago, and still hear it a lot more to this day, to really target individuals with stuff that they think that they are going to want to buy. For example, anyone that has an Instagram account, you typically get to see, you don't have to scroll too far, maybe only one or two posts from your friends, and you'll see something, for myself, a company called 10,000, love their shorts, love their clothes. They'll probably hop up on my Instagram every now and then wanting me to buy something that they have a special deal with. Obviously, there's some other factors that play into it, but that's just kind of an example of data being sold and us not really knowing where it goes, even though it's, supposed to belong to us as our data, name, date of birth, and other things that can kind of constitute personally identifiable information. You'll kind of hear that PII term used around, thrown around quite a bit. As just an acronym, so you don't have to say the whole thing over and over again. Saying, personally identifiable information can be quite of a mouthful and take a couple breaths in order to get through. So PII, just for short, makes it easy for everybody, for myself and you. And you sound a lot smarter when you say that and not have to question around what do they mean by PII, thinking about many different things that it may be that it's not. But anyway, I kind of digress a little bit. Let's excuse me, jump right into some of the stuff that we can see. So, this law, pretty similar to some others we've seen recently. Virginia, Colorado come to mind. I know that as of this recording, we saw Connecticut pass their own statewide privacy bill. That one is currently within the 15-day window to be signed by Governor Lamont. And all signs point to that's going to be the case, unless, something strange happens where he doesn't pass it, and then it has to go back through, and we'll kind of, watch that song and dance be played out until it finally does end up getting passed, just because of the majority support for the bill. But a lot of what I've been hearing kind of points to the fact that it'll be passed. But anyway, we're talking about Utah. We're not talking about Connecticut. We'll do that in another video. But Utah specifically, so Spencer Cox, governor of Utah, signed this bill into play, and a lot of good things to come about of it. I mean, obviously no one's gonna, it's not gonna be perfect, and there'll be some amendments later on to it. Virginia just had 3 new amendments come up, not explicitly kind of around the privacy implications, just kind of around some of the, if I remember right, enforcement activities and other stuff. But so March 24th, 2022 was the exact date that the bill was signed. This ended up going into effect at the end of next year. So companies have quite a bit of time to prepare for a lot of the different requirements that are included in this bill. And it's just going to be interesting to see how that kind of plays out. Obviously, this is more of a lawyer's realm, not necessarily a technical data privacy individual like myself. I'm not a lawyer, nor can I offer you legal advice anyway, but I can give my take, and hopefully you get a chance to kind of share your own thoughts about it, and let me know if there's somewhere that maybe doesn't line up exactly with the way you understand things. I'd love to hear from it. But this one has a lot of similarities to Colorado and Virginia, which is great. You know, it makes it a little bit easier for companies, especially doing business in some of those states, to be able to easily transfer the protections that they have in place for certain state residents to other state residents. So it doesn't have these huge hoops you need to jump through. California is a bit of a different one. That one has a little bit more to it, especially with the CPRA that was passed recently, kind of adding to some of the requirements that were in the CCPA. Not really going to go into those in this video, but we got a couple consumer takeaways I want to get to. And there's primarily 10. I may mention a few others that kind of apply to other companies and the applicability of the law, but there are 10 main consumer takeaways that I want people to understand by the time you get to the end of this video. So the first one, this is a big one. And honestly, it's, I say it's big. It's only because of who actually has the power to enforce the requirements of the bill. California allows their own citizens to take action, but in this bill, much like Virginia, Colorado, there is no private right of action for Utah. So that means that no specific individual, myself, not a practicing lawyer, cannot take legal action on my own behalf for an infraction of the act. That would have to be carried out upon request to the Attorney General, and so of this, obviously, of the state of Utah. So you're not necessarily going to be able to enforce your own rights, but there is a stipulation in the law that the controller has to provide the consumer the opportunity to contact the Attorney General in the event they believe that their rights as a consumer are being infringed upon by the way the company is operating. So kind of, interesting. Life goes on. That's going to be no different than a lot of states other than California. They like to do things differently out there. Next big one, number 2, access. So this is pretty much exactly what it sounds like. It is a consumer's right to access their data. So a company has my name, email address, and date of birth. I have the right to submit a, notification, email, however the controller sets up the contact method. I have the right as a consumer to ask what data do you have on me, and then provide back. They have to go through these. They have to authenticate my request as well. We just saw Facebook and Twitter recently provided data to someone that conducted a cyber attack. I don't know all the details around it, but I just saw that and thought it was pretty funny that they chose not to authenticate the requester, and they might have their various requirements in place, but it just wasn't enough in order to get actual confirmation that who they were providing the data to was in fact the person that was requesting the data. So, access. We can access our own data that the company has on us. We have to just confirm we are who we say we are. Pretty simple deal if you're following those layout. The next key takeaway, correction. So the consumer has the right, it's actually rectification is in the act, but it means the same thing as correction. If you see that there is incorrect data on you that the company has, you have the right as a consumer to take action and have that corrected. The company can't be, and a lot of times the company will probably be compliant with this. No one wants bad data. I mean, you helping them correct something is going to help them in the long run as well. Just kind of, it obviously depends on why you gave their data, but just kind of personalize the services a little bit more for you. Next one, right to delete. This is the 4th one in our list of 10. So if you're a consumer and you don't want the company to have your data anymore, you have the right to request the data be deleted, and they have to also provide you with confirmation that the data was in fact fully deleted and erased from their records. How they do this is completely up to them, but it has to be understandable for the consumer, for you and myself. We need to be able to actually see and understand, yes, my data was in fact deleted and you can't find it anywhere in their systems anymore. There's a 45-day window that they have to comply with consumer requests for that kind of stuff. And if they don't within that 45-day window, They have to provide reason why they need to extend it, and they can do another 45 days. So we may see that kind of play out a little bit, especially if the controller starts to get overwhelmed by consumer requests. You can definitely expect a lot of, hey, we can't do this in 45 days. We're gonna need some more time. Best advice, just kind of, I guess, be patient in that situation. And obviously, as American citizens and citizens of whatever state we're in, I live in Texas, but if citizen of Utah and some of the other acts, that this has not been something in place to this specific extent, requesting data on yourself and then being required to provide that. So best advice is to be patient, and we'll kind of see how this plays out and be able to form a different opinion later on. The next area, data portability. So this one kind of, it's in the name of HIPAA, Health Insurance Portability and Accountability Act. So, general definition of portability just means you can take something from one place to another with, ease, basically. So you can take your data that the company has, all of it, and they can, they give all of it to you, not in a copy, like you're copying a Word document to somewhere else, but literally giving something like a hard good away to someone, not making a copy of it, but giving the actual goods away to you so you can go take that somewhere else. And they have to do it, same time frame will apply, and they have to do it in a way that you understand what you're looking at. They can't give you something that's just Aramaic, as one of my colleagues likes to say. Whenever you can't understand something, might as well be written in Aramaic, and that's true for a lot of us that are not technical professionals to that extent, to where we understand the ones and zeros behind what's going on and can read the incredibly advanced code that's been written that is in fact our data, but it has to be provided in a method that the consumer can understand. And if you can't understand it, you can reach back out, and they have to provide you with the understandable reason. They may walk you through it to help you understand it, but obviously we'll see that play out whenever 2024 rolls around. Next one, opt out of sales. So you have the opportunity and the right to opt out of any sort of sales and targeted advertising. Or I'm sorry, not targeted advertising, but you have the right to opt out of sales of your data. That means that the company, if in fact it sells your data to make money, you can opt out of them selling your data to make money. That's a pretty standard basic provision. You'll see it in a lot of other state acts as well, where they're giving the consumer the opportunity to say, no, I don't want my data to be sold and make money on your behalf. General provision, we'll see that in a lot of other ones, Colorado, Virginia, Connecticut. The opt-in decision. So each state's going to be a little bit different. I mean, I say a little bit different. They all follow roughly 4 or 5 buckets, categories for this. So Utah specifically, 13 years of age is the age that a consumer has the right to opt in to, processing. So all of these different things that we had. Basically, by the time you're 13, that's when Utah says that you have the right to exercise all of these acts that we've been talking about. The controller must provide notice. So we're getting down to close to the end. This is number 8. The controller has to provide notice, and that is notice of, hey, we're collecting your data, we're processing it. This kind of rolls into number 10, we'll get to in a second, but we're collecting your data, we're processing it, we're going to be doing XYZ with it. Just general notice, the data is being collected, this is where it's going, this is what it's going to be doing with it. Number 9, a controller cannot discriminate against data subject. So this is a general term, meaning the controller cannot withhold services or charge a premium to you if you've requested your information from them. So there could be an instance where you purchase some kind of services, subscription or otherwise, let's say Netflix, for example. You purchase a subscription from Netflix, whatever the price is now, I don't remember, $13 a month. And then you go and request your data from Netflix. Netflix comes back, and decides to up your subscription rate because you requested your data from them. They obviously can't do that. I don't think they would do that, but this is just kind of a very basic example. In addition to that, a company cannot charge you to get your own data from them. That is also something that's a stipulation. They can't charge you a premium price in order to both request and receive your data from the company. That would be selling your data to profit off of. So they can't be doing any of that either. Last one, number 10, and then we'll go into some applicability for companies. The controller has to provide purpose for the processing. Talked about a little bit about this earlier. Why are they collecting data? Is there an explicit process in place? Can I, as a consumer, access that process and see, okay, this is what it is? It's all these things we've talked about is just to kind of hold companies accountable for, doing what they say they're going to be doing with your information. Obviously, there's a lot of it all applies to collected data from consumers. There is a bit of a gray area. This is more, you lawyers can come in and talk more on. If they cannot realistically identify you with the information they have, for example, myself, if they just had my first name, so Hunter, and then they just have my date of birth, you might be able to pin it down a little bit to find out, I am who I am, but the first name and date of birth together will probably be pretty difficult, especially since my name is not, incredibly common, but it's also not uncommon by any means, especially in America. So, not likely to find Hunters born on date XYZ as, narrowing it down to one person. Now, if they included my last name, it'd be pretty easy. I'm pretty confident I'm the only person in America with my first name, last name combination. So, keep that in mind as some of the personal information. They need to be able to identify you. And if they can, you can exercise all those rights. So we'll go into a little bit of applicability for companies. There's a pretty low bar, in my opinion, for companies that would fall under this law. And again, you lawyers would be, say yay, nay on a lot of this, but this is just what the law says, and that's what we're going to talk about. So the first stipulation, your company makes $25 million or more in gross revenue, straight up, not from selling data, nothing like that. Straight up $25 million of gross revenue or more on the books per calendar year. The next stipulation has two different parts to it, and one of these has to apply to your company. The first one has to apply, and then the next two, it's kind of like a step down approach. If the first one applies, then let's look at the next two, or we can even look at these two and then see if the next one applies as well and go backwards if we need to. But, essentially the 25 million gross revenue is one, one dot, whatever. The next one, we have 2A and 2B. So 2A would be if your company processes the data of 100,000 or more residents of Utah per calendar year. So if you do that, if you accomplish 1 and 2A, you're going to be subject to this act and kind of need to put the different protections in place and in order to be compliant with it. Lawyers, once again, giving you all shout outs for compliance. Love compliance. The 2B aspect of this would be that if your company generates 50% or more of their annual revenues from the sales of 25,000 data subjects. So $25 million gross revenue, 50% of that comes from the sale of personal data, 12.5 million revenue from selling personal data, 12.5 million from doing something else for entirely, who cares? The law applies to your company. And lawyers, once again, check me on that. Be confident. So those are some good things to take away. Kind of the main ones. You're going to have to kind of dig a little bit deeper if you want to kind of figure out what the requirements are that you need to meet in order to be subject, to non-scrutiny for the most part. Privacy notice is one of them. Controllers need to have that in place, need to have it publicly accessible. share with third parties, what data is going to them, etc. Next one is to establish and implement a reasonable administrative, technical, and physical data security practices. So you're probably doing a lot of these already, I would imagine, especially the cybersecurity realm. Any organization that has a cybersecurity arm, which God help us if you don't at this point, is going to have each of these controls in place. And so you may need to extend it a little bit further to encompass data and not just the systems, although in some instances, you probably will be covered by the data if your systems are covered as well. So just something to keep in mind for all of you cyber pros out there. As this stuff goes in place, you might be asked to do a little bit more, kind of depending on the applicability of this law to your company. Controller needs to present clear notice, opportunity to opt out. That is to be explicit for consumers. Opting out must be as easy as opting in. If it's not, then there's going to be a bit of an issue. Attorney General may be coming down. Obviously, which companies they decide to do this with is going to depend on the revenue, the eyeballs, for better for worse, how much that a case like that is going to make or break someone's career type of thing. The more notoriety, the better. But why risk it when you don't have to? It's a very easy plug. Just clear notice and opportunity to opt out, easy as opting in. They also must not discriminate against the consumer exercising their rights. We talked about this earlier when we were going through our 10 points. Just because you request a copy of your data or anything, the controller can't discriminate against you for doing such. And one last little bit, we talked about this already, but just reiterating, the 45-day threshold is the time frame a controller has to respond to a consumer request. Anything beyond that has to have a real reason for, they have to provide you, the consumer, with why that happened. So, pretty well protected for the most part. I'm sure if you dig deep enough and think of a little bit more, you can find some areas of this act that are really, not fleshed out as much as some of the other ones. So one question I want to leave, you folk guys with in order to be thinking about and how this law applies is, what if you're a nonprofit? Obviously, gross revenue is going to be an interesting topic of debate for companies around that front. And you process over 100,000 data subjects data in a calendar year, but you're a nonprofit. So, where's the applicability? I understand the kind of face value of a lot of things, but sometimes if you dig deep enough, you will be able to find some areas that are hidden under the surface and then be able to kind of act on it. So if you're a nonprofit, just kind of think, a little bit about this, ask some good questions. Are we covered? Is this even apply to us? Is it the data we collect on Utah residents at all, or is it on other people? But definitely good things to consider. This is going to be a fun law to see how things go. Virginia, like I said, already passed 3 amendments to their own. So we'll see if more come for Utah. But until then, appreciate you guys,